Good morning, Kenyans. My name is Sophie Wanjala. I am an advocate of the High Court of Kenya. Today, I am here to talk about police brutality. I start by defining what is brutality. Brutality is use of physical force. Brutality is use of excessive force. It is use of unjustified force. So when we are talking about police brutality, we are talking about unwarranted force, unjustified force by the police or by law enforcement officers. Now, police brutality is a concern. It's a very huge concern in Kenya. It's a contemporary issue, along which a lot of discussions are going on. When we are talking about police brutality, the scope of police brutality, we are talking about physical violence. We are talking about verbal violence. We are talking about discriminatory practices by the members of the police. We are talking about members of the police seeing someone as coming from a certain community or coming from a certain social status. That is discrimination. We are talking about using riot control agents. Riot control agents which are unjustified, and using the same agents against the protesters. So that is generally the scope of police brutality. So what are the examples of police brutality? If a police officer uses a baton to strike an individual, that is police brutality. Someone who is compliant, someone who is not defying the orders, that is police brutality. When a police officer kneels on someone's neck so that this person is not able to breathe, that is police brutality. When a police officer unjustifiably shoots a member of the public, that is police brutality. Verbal harassment, racial profiling, name them, that is police brutality. Now, there's a lot of consequences that arise as a result of police brutality. People are prone to be injured. There is physical injury. There is psychological injury to these people who are facing police brutality. There is lack of trust. Members of the public do not trust the police because they have seen what other members of the public are facing in the hands of the police, or alternative, themselves, they have experienced the police brutality. We are talking about legal ramifications. We are talking about members of the police service facing legal proceedings in court due to police brutality. Social disruption. When members of the public are shot, they are beaten unjustifiably, people are likely to protest, people are likely to riot, and therefore there is that social disruption of normal life, because people are picketing, people are running around the streets protesting the police brutality. Now, police brutality has a history in Kenya. There are a lot of documented records about police brutality. The most recent one during the COVID. If we remember well, during the COVID, there were a lot of reports from the Human Rights Watch, from the human rights defenders about police brutality. The people who are supposed to aid the Kenyans in observing peace, in protecting lives, in protecting property, they are the same people who are violating the same rights of the same people they are supposed to protect. And therefore, when we go deep into some of these records, they are very sad. They are very sad. So we are asking ourselves, is there a legal framework that governs the conduct of police during riots or any other function that the police have been assigned to? And there are various measures that have been put in place. There are various laws that govern the conduct of the police. First of all, we have the Constitution of Kenya. We have the Acts of Parliament. The Constitution of Kenya is a general framework. And then we have the Acts of Parliament. All Acts of Parliament are supposed to adhere to the Constitution. The Constitution is the mother of them all. Now, let's look at some of the legal frameworks that are in place to govern the conduct of the police and the conduct of Kenyans or other members of the public during riots or during protests. Now, we have the National Police Service. The National Police Service is headed by the Inspector General of Police. The Inspector General of Police comes into office through nomination, appointment by the president, following the recommendation of the National Assembly. Now, the National Police Service is made up of Kenya Police Service and the Administration Police Service. Now, the Kenya Police Service and the Administration Police Service, they are under the Deputy Inspector General of Police. The Deputy Inspector General of Police comes into office via appointment by the president. But unlike the Inspector General of Police, who is recommended by the National Assembly, the Deputy Inspector General of Police is recommended by the National Police Service Commission. Now that brings us to another body which governs the conduct of police. The National Police Service Commission is like a human resource body for the National Police. It performs human resource functions like appointments into the offices, determines promotions, it determines transfers, and exercises disciplinary control over the members who serve in the police service. Now we have the National Police Service Act. Now the National Police Service Act is very important. National Police Service Act of 2011 is very important because number one and the most important is that it gives us the role of the police. It gives us the role of the police and the limitations of the work of the police. Now, let me just read to you what the National Police Service Act of 2011 says about the role of a police officer. Now, a police officer shall always attempt to use non-violent means first, and force may only be applied where it is justified or where the non-violent means have failed to yield the desired results. Now, the 6th schedule of that National Police Service Act, it limits the use of force. This is what the National Police Service Act says. The force used shall be proportionate to the objective target to be achieved, the seriousness of the offense, whether the person is resisting, and even if force is used, it is only used to the extent that is justifiable to make sure that the police achieves whatever they want to do. So that the National Police Service Act is telling us excessive force is not allowed. Now, when we go to Article 26 of the Constitution, Article 26 of the Constitution gives us right to life. That means you only take a human life where it is justifiable. That also means whenever the police take a life unjustifiably, they are violating the Constitution. And so we are saying there are only specific circumstances where a police officer is supposed to use justified force within the law when they are saving a life, when they are saving or protecting property, when they are trying to prevent a person from escaping from lawful custody. So that when you see a police officer unjustifiably beating a member of the public, when you see a police officer unjustifiably using their gun to shoot an unarmed member of the public, that one is unacceptable. Let us talk about self-defense. A police officer is allowed within the law to defend themselves. Now, the law of self-defense is clear. You cannot use excessive force and say that is self-defense. If you are using a superior weapon than the person you are trying to protect yourself against, that one is not self-defense. Legally, it is not self-defense. And therefore, we can only say you are trying to defend yourself if the person you are trying to protect yourself from has either a similar weapon and they're charging at you or has a superior weapon. Those are the only circumstances under which self-defense is allowed as a defense against excessive force. And so when we want to see the bodies that deal with the conduct of the police. Now, number one, allow me to speak about IPOA. IPOA is formed under an Act of Parliament, IPOA Act, Independent Policing and Oversight Authority Act of 2011. Now, the IPOA Act enables the officers from IPOA, some of whom are policemen, to establish or rather to investigate conduct of police, so that when a member of the public has an issue with a police officer, they can go and record a complaint with IPOA. Now, we also have Internal Affairs Unit. Internal Affairs Unit falls under the National Police Service Act. Internal Affairs Unit, they investigate complaints against police officers internally as policemen. Internally as policemen. But now, Independent Policing and Oversight Authority has powers over Internal Affairs Unit, or IAU. So that we are saying, once the IAU investigates the complaint by members of the public, the IPOA can then come and say, the complaint was handled rationally, maybe they took a statement from the complainant, and the whole of this matter was handled judicially. It was handled fairly, the complainant is satisfied, the person who did the unjustifiable act has either apologized, or they have been able to made up, or they are going to face persecution. So that we are saying, once IPOA investigates and they are able to get the evidence, they do not have prosecutorial powers, unfortunately. They do not have prosecutorial powers to go to court and say, you see now, we want to prosecute this person. Once IPOA has finished investigating a complaint against a police officer, they forward their recommendations to the Director of Public Prosecution. It is only the Director of Public Prosecution who has powers to prosecute matters, criminal matters in court. And as we are going to see as towards the conclusion of this talk about police brutality, lack of prosecutorial powers by IPOA, I think it has been one of the ills that has been a negative ill against the IPOA. It has been something that has hindered IPOA from performing their functions properly. Of course, IPOA has its own gains, it has its own failures, but later on we are going to see, I do not work for IPOA, but legally and from our observation, we are going to see some of the disadvantages, or rather some of the limitations of IPOA as they try to investigate conduct against police officers. And so we are here and we are talking about police brutality. We are talking about the law that governs police. We are here talking about the body that investigates the police officers. Now, how do we address all these issues? How do we address police brutality? Now, some of the recommendations that I would like to put across, some of the recommendations will be, we establish other oversight mechanisms that oversee the conduct of the police. We fund IPOA. Inadequate funding for IPOA has been one of the reasons why IPOA has not been able to deliver the mandates. You find that IPOA has very few offices in very few towns in this country. So that when a police officer misbehaves in Turkana, there is no IPOA in Turkana. So that when a police officer does something deep down into northeastern, there is no IPOA there. They have to come to Nairobi, they have to go to Mombasa, they have to go to Kisumu. And therefore, it would be right to argue that IPOA is not adequately funded to establish offices in various parts of the country to be able to deal with police brutality in those regions, so that there is no need for police to in Nairobi or in Mombasa or in Kisumu to go and investigate a misconduct by a police officer in Turkana. It becomes a bit impractical to do that. Now, when we encourage members of the society and the police to involve themselves in community work together as people who stay together, that mechanism, I think it is bound to increase the trust between members of the public and the police officers. And I think when members of the public and the police officers have a good relationship, we are going to reduce the incidences of police brutality. Now, we need accountability measures. A police officer has been involved in a misconduct. Something needs to be done. The law says there should be a redress for every mistake, or rather, for every unjustifiable action that has been done, not just by police, although in this instance we are talking about police. So that we are saying when a police officer is involving themselves in a misconduct, they should be held accountable for their actions, not somebody else. They should be personally held accountable for whatever misconduct they do. Now, we need to collect data. We need to collect data about police brutality in general. We have a history of police brutality. It is going on even now as we talk about this. Now, we need to collect data. What has been happening? What is a pattern? Is there an identifiable pattern? Is there an identifiable trend in police brutality? Once we identify a pattern, once we identify a trend, I believe that we can be able to come up with solutions. Now, we need training and reform. Of course, we need further training. Our police officers may do well with further training on how to restrain themselves, perhaps not to use excessive force on individuals. Now, I wanted to briefly talk about what was ailing IPOA. Now, I have already mentioned two things. They do not have prosecutorial powers. They depend on the police to investigate and give them the data for them to be able to make a decision and forward those recommendations to the DPP, Director of Public Prosecutions. Now, they need adequate funding. If IPOA can be funded properly so that the offices of IPOA are able to be decentralized, so that they are closer to mwananchi in every part of this country, I believe that we can do better. I believe that they can perform better. That is all for today. Thank you.